Hello and welcome to Uncommon Law, my podcast about true stories from my life experience of over 50 years as a lawyer and trial judge. This is a look at the law from the inside out, stuff they don't teach in law school. This is Judge Rudy Greco, retired Justice of the New York State Supreme Court. In this day and age of the super tall, very thin, pencil-like skyscrapers in New York, people talk about those things. It brings me back to the mid-1960s when I was in college, and I worked my way in construction on real skyscrapers as a steam fitter. And as a steam fitter, I was a member of Local 638, the Enterprise Association. And steam fitters are the people who go in these tall buildings and put in the heating, ventilation, and air conditioning systems. Plumbers do basically a simple job of hot water supply and return, and of course wastewater supply and return. But steam fitters do all the intricate stuff where you have heating, ventilation, and air conditioning going on. And because I wasn't an apprentice in the steam fitter union and hadn't learned the trade, I was an amateur boxer, and my managers were foremen, and they got me in. And it was a great gesture. It was one of the best things that ever happened to me. But I worked on the bull gang. And the bull gang were the steam fitters who weren't great mechanics. The bull gang used to move the material, move the pipe. We used to 20-foot lengths of pipe and get it in off trucks, unload it, and using all sorts of equipment, and then hoisted up shafts 20, 30, 40 stories, and then the welders would take over and line it up and put it in, and et cetera, et cetera. We moved the material around the job. And my first day on the job, I was 32 stories above 3rd Avenue on steel beams, rolling pieces of pipe around from one piece of steel to the other piece of steel, and trying not to get too scared and look brave. My foreman on the bull gang, my deputy foreman on the bull gang, was a guy named Bill Scanlon. And Bill Scanlon was a tall, skinny Irish-American guy had grown up in Hell's Kitchen in the West 40s in New York City and worked on the docks until he couldn't. Bill was tall. He looked like Ichabod Crane. He was gangly and big nose and glasses and a little nearsighted. And I guess if you had to pick somebody out of a lineup to fight, you say, give me that guy. He doesn't look like much. And Bill Scanlon would kill you like a second cup of coffee. Bill Scanlon did 17 years in Dannemora Prison, top security prison, upstate New York, in Clinton, New York, which is known in prison circles as the Icebox. There's one warm day in Dannemora, I think it's July 4th, and the rest of it is covered in snow. And it's cold and drafty, and it's a very old place, Civil War, vintage place. And the toughest criminals in New York and in the New York penal system get sent to Dannemora. They go to Attica, too, and Greenhaven, but the really bad ones go up there. And I guess Scanlon was a bad one. He had a bad record. He was a cat burglar, but there was some violence involved. And his proudest boast is he burglarized the apartment of the then mayor, Jimmy Walker, who was a playboy mayor of New York. And Scanlon was very proud of the fact that he had burglarized Jimmy Walker's apartment. Well, eventually, Bill Scanlon got caught, and for one reason or another, maybe his long record and the harsh sentences they used to give out in those days, he served 17 years in Dannemora Prison until he was released via a New York Court of Appeals decision which exonerated him. But after 17 years, that was no big deal. He had already served 17 years, and he was a burglar, not a killer. And he used to say, and he told me as many times as I would listen, there is no justice in the New York court system until you reach the New York Court of Appeals. And that being said, he would say this ad nauseum. I've heard this, or ad infinitum. I just kept hearing it. All the rest of the courts, there's nothing doing, and this, that, and the other thing. People there's no justice, but when you get up to Albany and you face those 9 judges up there in the Court of Appeals, now you're getting justice. And he said that because he got released. Well, I had my own experience with the Court of Appeals. I've represented a bookmaker, a guy named Tommy, who's a very, very sweet guy. Tommy was a bookie, and like most bookies, he had a lot of integrity. He met his obligations. He paid his bets off when his customers won. He was a very decent guy. He was also the father of a little boy. He was a little league coach, and he was a scoutmaster. He was not a loan shark, but a friend of his, one of his customers, one of the gamblers that used to bet with him all the time, said, "Tommy, can you do me a favor?" He said, "My landscaper is desperate. He has to save his business, and he's looking to borrow money, and he doesn't have great credit, and he has to borrow it, outside of a bank and outside of legitimate lenders because he has bad credit." He said, "But the guy's not a bad guy, and he's a decent guy. He's a hardworking guy. You think you could lend him some money? He'd be good for it. He'd be good, and he'll pay back." And Tommy said, "Well, I don't lend money." He said, I'm a bookie." I said, "I know, Tom, but you could help this guy out. Maybe you could do me that favor." He says he's deserving, and he did it. So eventually, Tommy was persuaded. He gave in, and he lent the guy some money. Well, the guy paid Tommy 3 or 4 times. Made I think they were monthly payments. I wasn't sure. I don't recall now. And he made his payments, and with the interest, I guess it was 6%, until he defaulted. After about the fourth or fifth payment, he defaulted. And Tommy had gone to see him to pick up his payment, and the guy said, "Tommy, I can't pay you. I don't have the money." Tommy said, "What do you mean you don't have the money? I just took a trip out here to pick up a payment." He says, "I know, Tommy, and I guess you probably want to break my legs, right?" And Tommy says, "Are you kidding? What are you talking about?" He said, "I just came here to pick up the money." He said, "If anything, I'm upset because you could have saved me the trip if you didn't have the money today, so you'd have it next week. What's the difference?" He said, "I would come back next week, but you made me waste time having to come out here." He says, "You could have said something." "Oh, Tommy, you sure you don't want to break my legs?" Well, Tommy kept saying, "Don't be ridiculous." And the guy kept pushing it. And we found out that he said that, and he used those exact words. Why? Because this son of a gun, the borrower, okay, the deadbeat, was wearing a wire. He probably borrowed money from any number of people, and he went around and recorded all of these people and got off the debt by cooperating with the Suffolk County Police. Next thing you know, Tommy is indicted for usury in Suffolk County. Now, with his record, he had some minor charges against him as a bookmaker and stuff like that. He didn't know violence or organized crime or anything like that. He was a baseball coach and in Little League, And he was a regular guy. He was a suburban daddy, a little 6-year-old kid who he adored, little son. And shouldn't have been a problem. This kind of a case more than likely was going to end up by any experienced lawyer's estimation, with some kind of probation, maybe an E felony, the lowest felony, and get 5 years probation or something like that. Well, it didn't quite work out that way. And it didn't work out that way because the judge that we drew had two problems. He was inexperienced and he was mean. And he was a nasty guy. He was not only nasty to the people who appeared before him, he was very harsh. And he was harsh with the people he worked with. They wouldn't offer any guarantee of sentencing. The district attorney said, "Well, what we'll do is we'll remain silent on the plea. We won't recommend any sentence, and we'll leave it up to the judge's discretion." And the judge wouldn't give us any other plea bargain other than leaving the sentencing up to his discretion. And the alternative was to go to trial with all the evidence recorded on the wire that the creditor, the deadbeat, and the informant had worn. So we were going nowhere fast. So we had very, very little choice. And after a lot of discussion and consideration of all the alternatives, Tommy decided he wanted to take the plea, even though it was an open-ended plea with no guarantees of any sentence by this judge. Well, Tommy underwent a sentencing report and an investigation and everything else, and it was pretty good. It was no real big problem. And the day of sentencing came around, and we had to face this judge and see what this guy was going to come up with. And I was hoping for the probation. I expected probation. I got to the courthouse early, and I was talking in the courtroom with one of the court officers, and I tried to get a feel because this judge had no real record to go on, and other than he was basically a mean-spirited guy. And I asked the court officer, I said, "Listen, what about this judge? What do you think of this guy? Is he okay?" And the guy said, all I'm going to tell you, counselor, is if there's a shootout in the courtroom, stay away from the judge. He's getting the first bullet. And that was heartening. I said, oh, Christ. Oh, no, not that. Well, we went before the judge, and the judge basically nearly threw the book at him. He didn't give him the maximum he could give him, but he gave him 3 years in jail. In jail. Ridiculous. No probation. Immediately, I filed a notice of appeal to the appellate division, which is located, the appellate division of the New York Supreme Court, for the second department, which encompassed Brooklyn, Queens, Nassau, and Suffolk counties, and that's down in Brooklyn. So I filed a notice of appeal and perfected the appeal, got a brief ready and everything else. And my argument was that the sentence was overly harsh, and there was nothing here, and the fact of the matter was the judge overreached, and the indictment was improper, which I'll get to in a minute. The indictment was invalid. It should be invalidated and thrown out. It was a 4-judge panel, and when I was done and when the district attorney was done with his case, the judge heard and said, the defense argument in this matter, the presiding judge, it was a 4-judge appellate court, he said, and he's an old veteran, he said, is the best oral argument I've ever heard in my years on the bench. Well, my chest swelled up, and I went home and I told my mother, the judge said it was how'd it go? It was the best argument ever, the judge ever heard. And I, boy, oh boy, you couldn't get better than that. I had great expectations. Well, I got the decision about a month later. I lost unanimously, 4-0. Years later, I met that judge at a funeral, and I said, Judge, do you remember me? I was on the case with Tommy, such and such, the usury case. He says, of course I remember. Yeah, he says, that was a great argument. I said, Judge, you said that. It was the best argument you ever heard. He says, it really was. I says, I lost 4-0. I says, well, he says, that has nothing to do with it. He says, the law is the law, and, we went with the law. He said, but it was. I says, oh, my God. I said, well, I started kidding him around. And I said, I'm glad you like the argument. What happens if you don't like it? Do I get disbarred? I mean, what happened? And he started to laugh. Oh, come on. He says, don't be like that. He says, you win them, you lose them. I said, okay, thanks a lot anyway. Well, the quest didn't stop there because I thought this was a major injustice. And losing 4-0, there were no dissents. That unanimous loss meant I couldn't go any further. I couldn't go to the highest court in the state, the New York Court of Appeals, where Bill Scanlon says justice starts. I couldn't even get there unless I got permission to go there. And how do you get permission? They call it certification. You had to get your argument, your case certified. In other words, you had to get permission granted. It had to be a subject or an issue presented that the Court of Appeals wanted to rule on, something that was serious and maybe needed to be addressed by the Court of Appeals. And I was assigned for certification to Judge Lawrence Cook. Judge Larry Cook was an associate judge of the Court of Appeals. He was pretty new on the court. But when he was in the lower court, the appellate division for the 3rd Department up in Albany, he wrote the best decision on my issue that had been written in 100 years. It was the strongest decision of all. Case called People v. Clough, Clough. And I presented my arguments and went up to Sullivan County, Monticello, where the judge's home chambers were. He had chambers in Albany and he had chambers in his home county. And he was very gracious. A young man named Mark, who was assistant district attorney in Suffolk County. He came up for the other side of the argument, the prosecution side of the argument. And the judge was a sweetheart. He gave us coffee and donuts and said, come on, sit down, fellas. Let's talk about this, and I'll sit down the rules. Okay, Rudy, it's your petition, so you'll go first on behalf of the defendant. And tell me why this case should be heard by the Court of Appeals. And then, Mark, you'll go and you'll oppose what Rudy said. And then, Rudy, I'll give you a chance to reply. And, fellas, no interruptions, okay? When one of you is speaking, I don't want to hear any interruptions, and we'll go from there. So I argued before Judge Cook, and I said, Judge, here's the story. I said, first, aside from the fact that this was harsh, that's not really the issue. The issue is here that 12 years ago, when the Code of Criminal Procedure was repealed and replaced by the legislature under a new title, the Criminal Procedure Law, short-form indictments were outlawed. They were discontinued. Yet, in 12 years, the state has continued, as they have in this case, issuing short-form indictments. For instance, in this case, it's lending money. It's usury. A criminal usury is the charge. All they said to my client, they parroted the statute. All they said in the indictment was, Tommy, such and such, loaned a sum of money to an individual at a usurious rate. I said, well, that doesn't tell us anything. And in the Court of Appeals cases that I've read, I researched all the cases back 100 years, civil usury, which involved banks and businesses and stuff like that, and criminal usury involving individuals, the court has always said the same thing. There's a constant thread in all their decisions. When it comes to usury, you need details because there are multiple ways of computing interest. And how do you know it's usurious unless you know the method of computation? And for that, you need all the details. How much money, how long, what's the rate of interest, et cetera, compounded, not compounded. There were no details at all. And here we are, basically, with a short-form indictment 12 years after the fact of being outlawed. And the judge said, you know what? And I knew he was the author of that other case, which was favorable just below when he was in the appellate division. He said, I think this is an important matter that should be heard and decided by the Court of Appeals. I'm going to grant you certification. So I left. I came back from Monticello in the old Jewish Alps, which is the resort area of the Catskills, where Grossinger's and the Raleigh Hotel and all of those places were. And they got the nickname in New York City as the Jewish Alps because everybody would go up there, and most of the hotels were started by Jewish immigrants and farms, and that was the root of that. So I came back, and I was happy. It was a trip of a few hours, but it went quickly because I couldn't be happier. I just got certification, and the odds against certification, maybe one in every 75 criminal cases gets certification. So that was pretty good. And the odds are even longer on cases where somebody had to plead rather than was convicted by a jury or a judge in a trial. I was delighted. Comes the big day. That year, we had, my partner and I, Joe, had a case in the Supreme Court of the United States, and we had one in the Court of Appeals, which is rare. For anybody to get to the highest level of any court system is a rare proposition. 99 to 44, 100% of the lawyers never see any of those courts as participants in any cases. And here we were, ready to make law. So I went to the Court of Appeals, and I presented the case, and basically I said, there's 100 years of this court's decisions, civil decisions and criminal decisions, that are on my side, and say you need details. And here I got no details, and the state law changed 12 years ago. There are no short-form indictments as of 12 years ago, and here we are, and I have a short-form indictment. The decision came down months later, and I was denied. Tommy went to jail, and he served out the better part of 3 years. However, 6 months after that Court of Appeals decision denying our appeal, the legislature changed the criminal procedure law, amended it to say that in all criminal cases from here on, a short-form indictment is permitted as long as it's accompanied promptly thereafter by a bill of particulars, which means they would lay out the details. You could have a short-form indictment, but they would have to provide a bill of particulars, which is giving you in promptly details so that you could defend yourself and you knew what you were up against. And the professor who wrote the commentary in the law books that lawyers read, where all of this stuff is available to be seen and read and digested, is a Professor Denzer. And the books are called McKinney's. It's New York statutes, and all the statutory law is in about 60 or 70 volumes in McKinney's black leather books. And Professor Denzer was the guy who gave commentary on all the new rulings and all the new statutes and all the new decisions from the Court of Appeals. And Professor Denzer said, this new law is the legislative response to the Court of Appeals decision in Tommy's case. So, in effect, the operation was a success, but the patient died. And as far as Bill Scanlon is concerned, there's no justice before the Court of Appeals. I didn't find justice, and Tommy didn't find justice at the Court of Appeals. And I think it's because my case was too broad in retrospect, and I believe that the Court of Appeals was not going to invalidate 12 years of indictments and open up the prison gates to everybody in all the New York State prisons because they were indicted with short-form indictments. I had caught the king with no clothes, and it didn't do me much good. Thanks for listening. Come back next week for another episode of Uncommon Law, lessons they don't teach in law school. I'm Judge Rudy Greco. Court is adjourned.